So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs.
A pregnant defendant violates her probation after being hit with a new felony charge. The state pushes for jail time, while the defense pleads for one more chance on the outside. But then the judge does something no one expects. She rejects both sides' proposals and creates her own solution. What follows is a powerful ultimatum that leaves everyone in the courtroom stunned. So here's the real question. Is the judge's decision a brilliant use of discretion focused on rehabilitation, or an impossible moral dilemma with no clear right answer? Let's break it down.
All right. The court is calling 2024 CR 4982, State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Patrick Clowns for the defense.
And are you Ms. Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
The judge brings up deferred adjudication, essentially a legal second chance. Here's how it works. The court pauses the guilty verdict and allows the defendant to prove herself on probation. If she follows the rules and completes the term successfully, the charge is wiped clean, as if it never existed. But if she violates probation, like in this case, that suspended guilty verdict comes back to life and the judge can impose a full sentence for the original offense. It's a high-risk, high-reward deal, and she just came up short.
All right, State.
Yes, Your Honor. Violating condition number one, on or about this 22nd day of May 2025 in Bexar County, Texas, the defendant, Briella Butler, committed the offense of possession of a controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
I'm sorry, was that true?
True.
Thanks, ma'am. We'll waive the remaining violated condition, Your Honor.
Yes, no, sir. Right, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, State, what are you requesting?
The state is requesting adjudication of guilt and revoke her community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967. And we're also taking into considerations a county court at 2 case 2025 CC 011626, which is a failure to ID.
All right, in defense, what are you requesting? Oh,
Your
you
Honor.
can't sign it.
Well, this is the
This is, okay.
Your Honor, we're requesting that you continue her on probation, to deny the motion, and to follow the recommendation by probation to send her into the MIC unit or some other type of supervisory program with zero tolerance.
I really don't normally do zero tolerance in this court because being on probation, you're supposed to follow the rules. So my question for you, or maybe for her, what have you done? Because you've been on probation since February. What have you done? Have you completed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Briella Butler.
What have you done?
I went to the 60 days NA or AA online virtual visits. I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. What was that controlled substance?
Methamphetamines.
All right. So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs. Hmm?
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley, I have an affidavit that they brought in.
Mhm.
It wasn't mine. I didn't stay at the scene when the cops came. My car, I just bought it, it was broke down, and I was at my mom's house, and cops pulled up, and when they pulled up, my friend ran off, and they immediately put me in handcuffs and searched the car,
So let me just tell you right now,
and
the only way you're going to be continued on probation if you go into inpatient treatment. We're not doing this zero tolerance thing. So she can either go into inpatient treatment, and because you're pregnant, they will accept you at SafeP.
The judge proposes SafeP, short for SAFPF, the Substance Abuse Felony Punishment Facility. But don't mistake it for a typical rehab center. This is a secure, prison-run program, a lockdown environment designed to confront addiction head-on. It's the last stop before prison, an intense, treatment-focused form of incarceration aimed at giving serious offenders one final chance to turn their lives around.